Okay, ladies and gentlemen, welcome to this panel on scaling your small business. Can you guys hear me? Just anybody? Okay, good. Ladies and gentlemen, welcome to this panel on scaling your small business through teaming, partnering, and joint ventures. I'm sure a lot of the people in the audience are either aspiring small business owners or small business executives. So this is a great panel for you guys to understand some of the nuances, especially with regard to joint ventures. I think what I'm going to do today is try to focus a lot on the joint venture program in general, because teaming and partnerships, I think most of you all probably have a good understanding of it, but feel free to answer or ask any questions that you might have, even associated with teaming and partnerships. We've got a fantastic panel today. It's a very diverse panel. We have, in no particular order, we have Stan Jones, who's the acting head for the program, for the Mentor Protege program, as well as the 8A program. We have Jim Fennell from Aronson LLC. We have Sharad Gumas, who's an entrepreneur himself and is part of a Mentor Protege from Red Cedar Consultancy. And we have Devin from Protare Law, who is a practicing partner in the firm and has great perspectives on the Mentor Protege program. So I'm going to start by just asking everybody to quickly introduce themselves. Stan, I'll let you go first.
Thank you, Jay. And again, it's an honor to be here in this DC GovCon. And thank you to Sunday for the invitation. Again, as Jay indicated, my name is Stanley Jones, Jr. I serve as the director for the Office of Management Technical Assistance and the acting director for the SBA's Mentor Protege program. So I am excited to be here and look forward to this panel. Thank you, Jay.
Sharad, you can go ahead.
Okay, thank you, Jay, and thank you, GovCon. It really feels unreal that a small business like ours is sitting on a panel here discussing how to do joint ventures. Started the company in 2011, seen a fair amount of growth, especially through our small mentor protege program and JV. We have put some stunning numbers together. We have won vehicles to the tune of about $55 billion, including CIOSP3 and Air Force CBs and things of that nature. So very excited to be here, very honored. Thank you, GovCon.
Jim?
Yeah, good afternoon. Thanks, Jay, and thanks to DC for allowing me to be on the panel. Aronson LLC is a full-service CPA firm focused on audits, taxes, and consulting. And we're working with government contractors. It's actually the largest industry focus of our firm, whether you're looking to get started with your first federal contract or looking to hang it up and exit from the company. We're looking to support folks through the entire life cycle. So again, can't thank you enough for including me, and glad to be here.
Thank you. Devin Hewitt.
Hi, thank you for having me on this program. First, let me say that I think it's wonderful the success this program has had. I participated in the first program that was held that Sundi and Manish and Smita put together, and now has grown triple-fold, which is, I think, a testimony to the interest that DC has in this area, but also the good work that Sundi, Manish, and others have done in making this a resource for the membership. I'm impressed. It's gone incredibly well. I am lucky to be invited here because I have been doing government contracts for over 30 years, although I know I don't look it. But I used to be a partner in one of the biggest law firms in the world and did government contracts and represented a number of very, very large Fortune 10 and Fortune 25 companies. After a hiatus overseas with my husband, I came back and ended up focusing on small business work, established a firm here in Tysons. We're going into our 10th year. I would say the majority of our clients are government contractors. I am head of the government contracts group and the most senior partner in the firm. The firm does, all kinds of things. My practice primarily focuses on protests. I've done over 200 protests over my career and have represented companies such as Leidos, SAIC, a number of companies that have been acquired by those companies, SRA, Task, and the like. But the majority of my clients are small businesses, and I spend a good deal of my time reviewing teaming agreements and joint venture agreements and helping companies apply to the mentor protege program and comply with those regulations. So I'm happy to be here and to provide whatever assistance might be necessary, so you guys are up on the new rules that were issued a couple of weeks ago.
Super. All right, so let's get started. So as all of you guys know, one of the key elements of being able to team and partner is the concept of the joint venture. And a joint venture is an opportunity for small businesses to combine their capabilities to go after solicitations together, especially in situations where you may not on your own fulfill the requirements of the solicitation. So you can do a joint venture with similarly situated or other small businesses, and there are certainly certain guidelines for that. But the other way that you can also do it is through what is called a mentor protege program, where the mentor is usually a larger business, and with SBA's blessing, you can create a relationship, and that shields you from affiliation in creating joint ventures once your mentor protege is approved. And now mentor proteges typically could be done by small businesses, but also by the 8A. Recently, the SBA has taken some pretty good steps to streamline the entire mentorship program. So I'm going to first call on Stan to talk a little bit about the mentor protege program from SBA and what are some of the changes that the SBA has put in place into that program. Stan.
Thank you, Jay. A great question. As most of you know, as Jay has alluded to, just recently in the Federal Register, we published our final rule where we're merging our 8A and our all small mentor protege program. This has been something that's been a tremendous lot of work in trying to get to this point. And we know that the 8A mentor protege program is the backbone of the mentor protege programs for SBA. That program started in 1998. So it has, 20 some years serving proteges and mentors throughout the country. And in 2016, we started our all small mentor protege program. And that program was built off the back of the 8A mentor protege program. So it was a duplicate program, but it was expanded to small businesses and hub zone businesses, service-disabled veteran-owned businesses, women-owned businesses, as well as, again, for that exclusion from affiliation. So it's a great program, and I'm excited to have led the 8A mentor protege program, and currently I'm excited to lead the all small mentor protege program. And we're excited that on November 16th, the rule becomes effective, and we'll have one, SBA mentor protege program, one program, one purpose. So we're really excited about that. But this new rule definitely offers some changes, but I think those changes are to the benefit of the proteges and the mentors. And one of the biggest changes is this 18-month enrollment period. And I know there was a lot of comments during the comment period where proteges and mentors, talked about, hey, especially proteges, we only have a 2-limit lifetime. And if for some unknown reason this relationship is not working, especially of no fault of my own, why am I being penalized? And the mentor can continue to have additional relationships. So what we have in our new rule is an 18-month period. I mean, there is some steps that we're going to take to verify that this particular relationship did not receive any benefits and nothing derived from it, no contracts derived from it. The protege didn't receive anything. So we have that new provision now that's going to be a great benefit to those proteges. And again, we heard this from industry. So we did hear you, and we were able to enact those changes. Another important change in our regulations is we previously had a 3-year recertification type process, and we've eliminated that. And now the agreements are good for up to 6 years. However, the mentor and protege can elect to have a shorter period for their agreement. That is their decision. But we don't have to come back and recertify every year or issue you a new letter every year saying that you're still valid. It will continue to be valid up to 6 years until such time that either SBA or the mentor or protege decides to terminate that agreement. And then, another key change is when proteges come in for work under their or mentor protege agreement under their secondary NAICS code. Again, we kind of strengthening that piece. So we talked about that the protege need to have prior experience and prior current work. Again, just qualifying what those expectations are. So we're excited about those changes. Again, this is a business development program. I really want to stress that. The mentor protege program is not a contracting program. We're designed to provide business development to those proteges to help them gain a foothold in the federal marketplace. That's what it's intended for. It's a quasi hybrid program because we have those joint ventures, exclusion from affiliation. That's what the mentors are looking for. But the whole focus of that program is business development. We want those proteges to gain capacity so that they can compete in the marketplace, so they can have some long-term sustainability in the marketplace. So we're excited. And I'm just going to end with this. When we merge the two programs, we're going to have over 1,500 active mentor protege agreements, which is amazing, tremendous. So we encourage those firms that are not engaged in our program to really, go to our website, sba.gov, and search out the mentor protege program and just find more about what we're doing, because it is a great tool to help your business succeed and continue to grow. Thank you, Jay.
Thank you, Stan. So, and that's exactly right. I think, and speaking from the perspective of even a mentor, my company Harmonia is a mentor to two different proteges right now, and it's also as much of an advantage to the protege as it is to the mentor, because especially for companies that have just graduated from the small business, you're in that proverbial valley of death where you're no longer small, but you're competing with the largest. This gives an opportunity for you to kind of continue to scale as you kind of get used to and learn to kind of compete with the big boys. So I think it's a great program that the SBA has put together. I think it's a win-win for both the mentor and the protege. So let me turn to Devin. Devin, I know you probably put together a bunch of mentor protege agreements as well as the joint venture agreements under the mentor protege. With the changes, and how do you see the advantages and disadvantages of this? What would be your advice to some companies and how they could sort of take advantage of the mentor protege program as well as some of the changes now that the SBA has implemented?
Well, we talk a lot about joint ventures in the context of the mentor protege program, where a large business is a mentor and you have a protege that's a small business. And one of the key advantages of that program is the ability of the two to form a joint venture and bid on small or 8A or a certain flavor of small business set aside. And the large mentor gets up to 60% of the work. I mean, that's a key aspect that is favorable to large businesses. But joint ventures also serve a purpose for just small businesses. And there are a number of joint ventures where small businesses team together because they all have varied resources or capabilities that are symbiotic and work well for a particular acquisition. So the new rules that have come out address joint ventures in different contexts. Joint ventures in the mentor protege program, joint ventures generally speaking. One of the big benefits of this rule is that it clarifies a number of issues that have come up through litigation. Joint ventures are really very complex teaming arrangements. Teaming arrangements where there's a prime and sub have been around for decades, and the structure and the responsibilities of each party are fairly well known. Subcontracts and teaming agreements have a natural flow, and the issues that come up are very familiar. Joint ventures are a very sophisticated legal construct, And there are issues that arise with joint ventures, regardless of whether they're of a small business nature and subject to regulation, as they are here in government contracts. So you already have the difficulties that come with a joint venture legal construct. And then on top of it, now you have regulations. And so the combination of both, when these were first permitted, created a lot of questions. How they interacted, whether or not it made sense for some of the rules that made sense, but did it make sense in a joint venture context? For example, one of the big issues about joint ventures is that SBA views them as a limited purpose, limited duration entity. And that's actually indeed how they are viewed in the commercial marketplace. Joint ventures were created originally for real estate investments. And then were done for international public projects. And the idea was that you would have these capabilities come together to form a unique entity that would focus on one project. And so there are rules, obviously, about the term of the joint ventures, and that is 2 years. And then, of course, SBA limited the number of contract awards to 3 and 2. It was known as the 3 and 2 rule. But the start and the finish, and whether or not it was really efficient to form a new venture after that 2-year period expired, there were a lot of questions there. So now that it's been simplified, the rule is simply that a term of a joint venture is 2 years, period. And that 2-year period starts from the date that joint venture receives its first award. And that joint venture can receive as many contracts as it gets awarded during that time, as well as contracts that a bid has been submitted before the 2-year expiration, and contracts are awarded pursuant to that bid elsewhere. So there's no limit for 3 contracts. And so that allows the energy and the momentum that a joint venture has from the beginning to maximize the participation of the two joint venture members, whether that's a large or a small. The other significant issue, I believe, with these new joint venture regulations is security clearances. Again, in the context of the idea that a joint venture is a limited purpose, limited duration entity, and combine that with the rule that SBA has that they are unpopulated, it is not rational to require that joint venture, which is really a legal construct, to have a security clearance, because the security clearance runs to individuals and performance and facilities that a joint venture, if it's done for a limited project, does not have. And so the benefits of a joint venture, the combination of resources and personnel and past performance that was allowed and afforded by these rules, was not reaping the benefit in contractor acquisitions that required security clearances, because many agencies required the entity itself to have the clearance, and yet the entity could not get the clearance because it didn't have the requisite people or past performance that was necessary to obtain those clearances, and not the contracts in the past. And so there was a lot of gymnastics, if you will, in trying to get that joint venture a clearance, usually the mentor or one of them subcontracting and then sponsoring the joint venture for a security clearance. But, were they really doing any work? Anyway, that's all cleared up. The bottom line is that now, as long as the member of the joint venture has the security clearance necessary for that member to do the work, that's fine. So I think those two are big changes.
Thank you, Devin. Those are really good points, especially the point about the security clearance, because I know we kind of went through that. It's particularly combined with the fact that, DSS is so backed up, it's impossible for a joint venture to otherwise get a security clearance. All right, so let's move on to Sharad. Sharad, you're a small business owner. You have been in a mentor-protege relationship for about 3 years, you told me, right? Well, I should know. Our company is your mentor, but so here's a question for you. Based on your experience, here's my question for you. Who do you think is going to win the election?
I'm going on mute.
Okay. Maybe that you probably are not experienced enough to answer that question yet.
Oh God, yes.
So question for you. How has the Mentor Protege program helped you? What are your thoughts? What are some pieces of advice that you can provide to other small businesses contemplating a Mentor Protege agreement, or who are in a Mentor Protege agreement? How can they leverage and maximize the benefits from that?
Thank you, Jay. Yes, I'll certainly share my experience. So we started being a small business, started in 2011, just as a staffing company or what have you. But then we started really establishing within an agency, started growing within that agency. And that's where we met our mentor, Harmonia Holdings, and did some sub work there, and sort of grew that relationship. So we went into the dating phase, so to speak, within those couple of prime sub relationship we developed. And we then saw that there is definitely synergies here, that if we at that time Harmonia was also planning for graduating out of small business in the next 2-3 years or what have you. So it was a quite a bit of proactive thinking on their part. But for us, from company perspective, we sat and thought about the fact that we could make all the mistakes ourselves and slow down the process of growth, or learn from others' mistakes, and take advantage of the infrastructure and other areas that our SPA set out to have mentors to help the prodigies with, and take advantage of those from our larger partner, and grow very quickly. So that was the thought behind us signing up into Mentor Prodigy program, which is the true intention of what SPA has in terms of, especially we were not an 8A, and so at that time the programs were different. And for a non-8A, there was no easy path. We were hub zone. We are still hub zone. There was no easy path for a rapid, learn the process, learn the ropes, and get to business type of thing. So that really helped us to gain commitment from our mentor to help us in the 5 areas that SBA has recognized to help us. But what I would advise companies out there looking for this is to do your due diligence, make sure that the wedding and marriage is going to work, right? Give yourself maybe work as a sub relationship for a couple of contracts, and ensure that. But the other thing to keep in mind is keep the true intention of what this program is, that you're learning from the mentor, that you don't lean on the mentor. So as but it could be in the management areas, business development. For example, we signed up with Harmonia as the mentor to help us in business development, because we know that they have a very strong business development wheelhouse. But when you're doing that, you, as a small business, you need to know where to put your investment, but you need to learn from that and establish your own, because you can't rely on it. So that's the two couple of things I can share from my experience, in the sense, go with the true intentions, go with knowing that this will work for at least 3 to 6 years, and that you're always learning and trying to establish the same units on your side as you grow with them. To take the wheel, be ready to take the training wheel, so to speak.
Thanks, Sharad. And for everybody who's out there listening, I promise you I didn't twist Sharad's arm to say those things. He kind of said that on his own, and I see Stan laughing there. All right, Jim. So one of the things that you've kind of talked about in previous conversations I've had with you is that for a small business, they really need to try to maximize their time in the small business program. And I agree with that. I mean, the whole idea is, because you really don't want to get, when you're doing teaming and partnering, you don't want to be in a situation where you've got what I call zero gain revenue, where there's no real profit. You're getting some partners, but you're not really getting any money that you can use for your own business development and stuff like that. So from your perspective, when you advise people, how can the Mentor Protege joint venture program, right, or the joint ventures under the Mentor Protege program, or even just joint ventures in general, given that they're unpopulated, how can they help to sort of accelerate, to sort of help that extension of small businesses in their maturity curve and staying in the small business program long enough?
Yeah, thanks, Jay. You know, this is a question we get so many times because, you know, as you've already heard throughout the conference, you know, the federal government has exceeded the amount of awards, you know, contracting dollars that went to small businesses. It was over 26%. And so as you're growing as a small business, you want to maximize your time to be able to bid on those set asides, right? And we don't want to see companies graduate too soon. As much as we want to grow, we want to grow smart. And I think where joint ventures come into play, even though there's a lot of other pros and cons, is there's a specific strategy to help you maintain the companies being a small business. And so I'll explain what that means. And it's not only mentor protege JVs, it's also general JVs as well. So what happens is, if you think about the traditional teaming agreement, if you're teaming with another party and we're going to prime sub, and let's say an opportunity is a $3 million opportunity, and your company's going to do $2 million of the effort, right? And the sub's going to do $1 million of the effort. Well, what happens with the revenue reporting associated with that as it relates to, you know, the definition of are you small or not? Well, you're going to pick up both $2 million plus the $1 million. You're going to pick up the prime plus the sub. And so those numbers all lead to the calculation to whether or not you've exceeded the size standard under revenue thresholds, right? There's also employee thresholds, but in this case, we're talking about revenue thresholds. Now, if we contrast this to the joint ventures, right? Same two parties. You know, your company is going to turn around and subcontract to the joint venture for, let's say, $2 million worth of work. And the other party is going to subcontract in $1 million worth of work to the joint venture. You're only going to be picking up $2 million towards your size standard, right? And so, you know, there's a lot of other reasons to consider why and why not to do a joint venture. But I think, again, what it comes back to is we want to see companies grow smart. What we don't want to see is a company barely graduated out of small business because they just missed the revenue threshold by, you know, a couple $100,000. We want to see companies blow out of that threshold. And by having things like joint ventures, and there's some other strategies as well, you can buy yourself a little bit more time. You know, one more year in a set aside program can make the world of a difference for a company to have that cash flow from the contract to help build infrastructure and just be ready to go compete full and open.
Points, but let me, I think you made a really, really important point that I'd like to kind of bring out. So just to be clear, when there is a joint venture between, let's say, a mentor protege, a large and a small, or even two companies, the two companies that are part of the joint venture, they are subcontractors to the joint venture. So if the joint venture wins an award, like you said, for $3 million, and that's, you know, in your example, divided into 2 million and 1 million, the actual revenue that accrues to the two partners is 2 million and 1 million. So they're not, so they're not really getting the sort of the zero gain revenue of the 1 million for the guy who's the 2 million partner, and vice versa, correct?
That is correct. That is correct. And what I'll say to clarify is, ultimately, if you look at the rules, the way the SBA looks at you know, revenue, is they're going to go to the tax return, right? And there's differences between revenue you record on your financials versus the tax return. But I don't want to get into the accounting because I think you'll lose some of the audience if I go accounting. But that said, the joint venture does, you know, allow you to buy more time and keep you below the revenue threshold.
Right. I was just kind of, I didn't want you to get into the weeds of accounting, but broadly speaking, I think just I wanted to kind of bring that out. Stan, so, you know, again, going forward with the mentor protege program, I know that you've talked about some of the changes and you've combined the 8A program, the 8A mentor protege, and the all small mentor protege program. And I think that's good because, I mean, we've kind of seen it. There have been some challenges trying to get, you know, the different programs and working with them. But even so right now, when it comes down to the 8A program and working with 8As and SBA, you know, there are certain things that when you're an 8A program or in an 8A business, you still need to get approved by the SBA. So in terms of the mentor protege, what are the things, what are the differences still between getting a mentor protege program if you're an 8A versus a small business? What are some of the things that you still need 8A to, SBA to bless before they can go forward? For example, one of the things that the mentor protege program allows is equity ownership in the protege company by the mentor. So what are some of the things that if you're an 8A business, you would still need to go back to the SBA and seek their blessings?
Thank you, Jay. Yes, for those firms that are still in the 8A program, although the mentor protege program is falling under the SBA mentor protege program, the 8A participants still have to comply with the 8A rules. So although you won't have your BOS requesting you to send in your annual report on what you did for mentor proteges, you're going to be sending it to the mentor protege team. All other things still apply, whether it's change of ownerships, whether it's, waivers, if you're trying to sell your company, waivers of terminations, T for Cs, so you're still going to have those requirements. And that's a good thing because, again, the 8A program is a business development program. So you have your servicing district office and your business opportunity specialist there to help walk you through and navigate through this 9-year program. So that won't change. I think one of the good things in the rule is that we've strengthening our rules so that we can better help those other businesses that are not 8A, those small businesses, those service-disabled veteran-owned businesses, when they run into issues with their mentor-protege relationship. So our new rule talks about a SBA will intervene on behalf of the protege to try to resolve issues where the 8As always had that because they had an advocate, they had a BOS. And now those other small businesses now have an advocate too, SBA. We can come to the table, we can come to your aid to help you navigate through problems and issues that you may experience with your mentor. And they're going to happen. I mean, they're going to happen. I was in the industry 20-some years, and we had those same problems with the mentor. You try to get it to the table and try to resolve those issues. So they will happen. So, but the new rule just strengthens that for those non-8A participants. And I do want to add, I know Devin mentioned something earlier about the joint ventures. I do want to add one other key change, and I may be stealing her thunder here, is that the 8A program, when it comes to 8A joint ventures, competitive or sole source, we were required, SBA was required to review those prior to award. And now the new rule, we will not be reviewing 8A competitives prior to award, only 8A sole source. So that's a big change. We're still working through how that's going to flow and work, with agencies and systems, but that is a big change to this new rule. So again, that's a benefit to the program participants because, sometimes it takes us a while to process things because, again, we have a heavy load, few resources, but that is a huge change. So thank you, Jay.
Thanks, Dan. Jim, question for you. I talked a little bit about the equity ownership that a mentor can take in a joint venture, right? From a protege standpoint, what do you think are the pros and cons of this? And it's up to 40%, right? What are the pros and cons that you think might the protege kind of think about? And for all panelists, I know we're kind of running out of time. We got started a little late, but try to keep your kind of answer short because I do want to keep a little bit of time at the end for Q&A. Go ahead, Jim.
Got it. Okay, I'll keep this brief, but this is a huge topic. I mean, how much equity you give up, whether it's to employees or whether it's to another company, is a big deal. That's the value you hold. And I think on a pro side, it's, with a mentor taking equity, I mean, they have more of an incentive for you to do well, or more of an incentive for them to position you up to do things because they want a return on that investment. That's the big, if you watch Shark Tank, you'll hear them say, hey, I want a little bit more. I want to be interested, right, in this investment opportunity. On the con side, I'll say what, a trap small businesses fall into is they'll give up equity when they shouldn't, or they'll give up too much equity too early. I mean, what the value of 10%, 20%, 30% is today is going to be very, very different down the road as you grow. And as you grow, you're going to need different resources. You're going to need, and that might be some key employees that the market might demand that they need some sort of an equity instrument, whether it's a real equity or phantom equity, or you might take private equity down the road. So you can only dilute yourself so much to a point where you're gonna feel like, hey, it's too much. And so looking ahead is kind of the key here with equity, but it's a big deal.
Thanks, Jim. Let me turn to Sharad real quick. Sharad, you've given up some equity in your firm. What are your thoughts on it? When you did that, why did you do it? How's it worked out for you so far?
Yeah, agree with Jim 100% on the part that we put a lot of thought through this. And the number one that came out of that for us is the commitment part. So what's the best way to have our mentor fully committed into growing us, right? JVs are fine, past performances are fine, but what is that get them, signing in blood, so to speak, is the investment, right? So that was our number one reason to go into giving up the equity. And again, so we were a small company, and we would need equity to hire at C-level or what have you. We did the right investments using the equity, and it has worked out for us very well, right? We have seen the commitment and helped us grow through there. But one thing I would advise the companies is to, it adds additional complexity in maintaining the relationship, right? Equity as well as the JVs and the profit share in the JV versus the company and things of that nature. So as much of a clarity written in each of the task orders we win or what have you on what the work share will be, and keeping it all clean is the way to go especially when you have the equity investment from the mentor.
Thanks a lot, Sharad. Devin, I have a question for you regarding affiliation, but I'm going to come to you in a minute because I think I'm seeing some questions around that as well. But let me just quickly ask Stan a question, just because Stan, ladies and gentlemen, I don't know if you know Stan. I know he's heading up the program at SBA, but he was previously a small business owner himself. And so I'm going to ask him that question. Stan, what's your view on the equity ownership piece? Real quick.
Real quick, again, this is a personal view. I know our regulations say you can get up to 40%, but I've never been a fan of it. Again, I think when you get into those type of situations, you're giving away your hard work and sweat equity that you've put in to build your businesses, and you have an opportunity through mentor-protege relationships, through joint ventures, through prime sub relationships to bring in, partners so that they can, play in the game that they're not eligible to play in. And again, so, again, a lot of these small businesses, these are mom and pops that have grown, from 2 employees to 100 employees. And, I wouldn't want to give up anything. I'll share, but not give up anything. That's just my opinion. Thanks, Jay.
Thank you. Yeah, I think that the competing view of that, of course, and I appreciate your viewpoint there, right? I mean, I think it's very well, very well put. I mean, I think that the competing viewpoint is, at the end of the day, again, as an entrepreneur, as a lifelong entrepreneur, my view has always been you increase the size. If you can increase the size of the pie, then there's usually enough for everybody to eat. If you're fighting over a slice of the pie, then there's usually never enough to eat, right? So I do appreciate everybody's sort of viewpoint on that. I'm gonna pivot over to Devin here. Devin, the question again is surrounding affiliation, right? So one of the key things that you've got to be very, very careful about is when you're working with large businesses, you don't want to get, for small businesses, you don't want to get to a point where you get affiliated. So while you're in the mentor protege program, there is a certain level of protection, and I say certain level because you still have to be careful, but there are certain protections in place for you to not get affiliated. The idea is that small businesses will still be sort of growing on their own and doing what they have to, and not be unduly reliant on a large business, whether they're a mentor. Now, what happens if somebody were to kind of, give up a 40% stake and they're in this program? How does that play into the affiliation rule from your standpoint, from a legalistic standpoint? How do companies ensure that they can kind of shield away from affiliation?
Well, that's another benefit of the mentor protege program. One of the key benefits are joint ventures, which we've talked about, but the other benefit that it affords mentors is the ability to take an equity stake in an 8A initially or a small business. And with respect to the 8A program, which was the basis for it all, if you weren't a mentor, there were limitations on the equity you could take in an 8A company. So a mentor and a protege, if the mentor takes an equity interest, that relationship is exempt from being a basis for affiliation, just as is the joint venture relationship exempt from affiliation. Otherwise, the companies may be affiliated. Joint venture members are automatically affiliated under SBA's rule, unless the exemption of the mentor protege applies or another exemption. The 40% interest depends on the level of control. But again, if it's in the context of the mentor protege program, there is an exemption there. However, SBA has said that the exemption that a mentor protege relationship enjoys under the mentor protege program is not absolute. It is typically tied to certain acquisition or acquisitions, and the equity stake aspect of it has to be looked at for purposes of whether control is exercised through that equity interest. So that is one issue. So, the affiliation concept is one that's based on totality of the circumstances. And so with respect to equity, I think it's about what comes with that equity in terms of control and in the future. So, on the surface, there's an exemption from the affiliation concerns, but it's not a complete pass.
Thank you, Devin. So I'm receiving now threats from the organizers that we are over time. But I'm going to ask one more question, and I'm going to bring that up. I guess I'll ask that to Stan because he's probably the authority on it. And the question is this: are JVs a feasible option for a small business to obtain a past performance call when they may not have one? I know that there is a rule around if your JV partner is another small business, or in fact, even as a teaming partner. So I think it's an interesting question. Stan, go ahead.
Yeah, it's an interesting question. I definitely would love to hear from Devin on this as well. I think the best way to get past performance, again, is through prime sub relationships. That's just, again, my opinion. You can get that experience from those other businesses in those type of relationships. I mean, JVs are an option, but it's a lot of work. Devin can talk to that. It's a legal entity that you're putting together. But I think, getting some subcontracting opportunity is a way of gaining a past performance experience as well.
I'd like
Devin,
to
go ahead, Devin.
Okay, so I'm going to take the contrary view. Actually, I think there is an extreme advantage for joint ventures because the small business can get experience and past performance as a prime, which is much more valuable than getting past performance as a sub, which a lot of small businesses, that's how they enter the market. So I think that there's something to be said. Now, there are limitations on that, but yes, I think it is a good vehicle for that.
Yeah, and let me just conclude by saying I think that I do feel like that getting past performance, is one of the primary reasons why you want to create a joint venture in the first place. I think one of the things that would be interesting, again, and then this is really much more for Stan, sometime in the future. I think what has been seen, if you look at some of the GAO decisions and what has happened, is that there isn't enough clarity, perhaps, on when you have two companies that are a joint venture, particularly in the case of a mentor protege. When the protege is a very young company and the mentor is a very large company, how much of the mentor protege past performance can be really used when it comes down to a solicitation? Does the agency have leeway? Is it appropriate? Is it in the order of 50-50? Is it in the order of 60-40? Is it in the order of how much work share they're going to have, right? It really just depends. I think there's some sort of clarity around that. And I know Devin's kind of, I can see Devin's sort of shaking her head and then nodding her head. So, but ladies and gentlemen, we're out of time. I'm receiving, even more dire threats now by Cindy and everybody else. So, but here's the deal. What I want to do is I think that there's some obviously the joint venture and the mentor protege topic is a very pertinent one. If any of the participants have any other questions, I would encourage you to reach out to the people on the panel. Okay, again, you know where to find Devin and Jim and Stan. I mean, they're all available, and Sharad can be a really good counsel as a fellow small business. And feel free to respond, to reach out to me as well if you'd like to get some advice on what's good and what's bad. But anyway, with that, I want to thank all the panelists, first and foremost, Devin, Stan, Jim, and Sharad, for your time and for your valuable insights. Thank you, Ty DC, for putting this together. I think it's a very pertinent topic. And thank you, audience, for being a part of this. Hopefully this has been helpful to you. Again, like I said, feel free to ask any questions directly to the panelists. Thank you very much.
Thank you.
Bye-bye.